This is Attorney Edward Reyes. I just wanted to go briefly over the paperwork when we first sit down, the questionnaire that we fill out, plus all the initial paperwork that goes within the packet, okay? So we'll start here. So the first thing you'll notice is the personal injury questionnaire. These are just questions to kind of get to know about you, a little bit about your family, a little bit about your situation, the insurance carriers, any information that could possibly help us will help us in the long run. Again, not all the information is going to apply right away, but as long as we can get as much information up front, it saves us more time and we're a lot more efficient. So if you notice, we talked about your insurance carrier, we talked about the defendant. The defendant is the person that caused the accident or the injury. And then we go over through employer. And the reason why we ask for your employer information, in case you lost work, lost wages, because if you were involved in an auto accident, it might actually reimburse you back for lost wages. Previous medical providers and previous accidents and things like that, we need to know these things because later on, this is going to come up on the opposing side, on the defendant side. They're going to come up and they're going to say you had all these issues prior to. So these are things we need to ask that we won't be blindsided later on. Agency, it's whoever made the incident. If it was an auto accident, it would be the police, the sheriff, Florida Highway Patrol, or if it was not, if it was a slip or fall or something to that effect, who wrote up the incident. Okay, so the next form we're going to see is the health insurance. It's the HIPAA waiver. So this form allows us to request medical records on your behalf. When you are involved in any type of accident, and if you are injured, we need to be able to have that information to help make our demand. So this is a form that we have to fill out, that we need you to fill out in order for us to request those medical records. Statement of client's rights. This is governed by the Florida Bar. It kind of just goes over your rights as a client. It talks about contingency fees that we don't recover unless you recover. It talks about you have the right to ask us about the attorney's education. If we have to make any changes or refer it out to somebody else, we need to inform you of that. And you have the right at any given moment to find out what your costs are, any fees that have been accrued, or anything to that effect. And also, as your attorney, you have the right to ask us, or we also have we need to tell you of all the consequences that potentially could go wrong with filing a lawsuit or bringing a claim of sorts. At the end of the day, you, the client, have the power of the settlement as well. Meaning, if you get a settlement and you don't like the settlement, you can choose not to accept it, or you can choose to accept it. As your attorney, we can advise you on whether to hold off or not hold off. But at the end of the day, you have the power to do what you feel like is the best thing for your situation. And then there's 10 basic rights. It just talks about things that I do to help protect you and your case, and how I work diligently in your behalf to make sure we work in a very efficient manner. Okay, the contingency fee agreement. This is pretty much the agreement that you make with the attorney, with myself, saying that we're going to work on your behalf. And it kind of demonstrates of how much money we would be collecting. Well, it doesn't say the amount of what we'd be collecting, but it does say when we do collect, it's 33 1/3% plus fees that goes toward the attorney. And it kind of outlines all this. It's like a staggered. If you notice 33 1/3%, then it goes into, if it's 1 to 2 million, it's 30. So it kind of gives you a description of everything and how that actually works. The Medicaid thing is basically, if there's Medicaid, if there's a lien on it, we have to satisfy the Medicaid lien. So if you use your Medicaid for whatever reason, whenever you sought treatment or whatever the case might be, there might be a Medicaid lien, and we need to know that because we have to reimburse them. And it just talks about if at any given moment, if you decide to not like in the middle of the case, you decide to fire us for whatever reason, there's potentially for a lien on the case, and just talks about for the amount of work that we've actually put into the case. Okay, so the next paper is the durable power of attorney to settlement checks. This is only giving us a very limited authorization. So whenever the insurance company is on the other side, the defendant, whenever they make the checks payable to the firm. We then put the checks in a trust account, and then from there we negotiate with your providers. With providers meaning your healthcare people that treated you, MRI facilities. Anywhere there's a cost, we negotiate with them, we pay them, and then we write you a check in the difference. So this is saying that the actual check goes into the firm, and then from there it's allocated property. Well, that's about it. I hope that this video helps. Just wanted to give you a good understanding of what the forms actually mean. And if you have any questions, feel free to call us. The number is 813-421-3411, or send us an email at contactus@thereyesfirm.com.